Hello. In this video, we shall be looking at the meaning and the classification of the thought of defamation, the meaning and the classification of the thought of defamation. And then the essence of this topic is to familiarize us with the salient points and the meaning of the thought of defamation and the classification, because how defamation is classified is significant in terms of the claim of the cause of action that a plaintiff may be able to bring before the courts. Now, the meaning of defamation, in simple terms, we can say that defamation is making false statements about a third party. In the first video on this topic, we examined the legal framework for the tort, and we were able to underscore the fact that the tort is meant to to try and balance the rights of two parties. The plaintiff's entitlement rights to his reputation and the defendant's entitlement to freedom of speech. So we laid that foundation. And in today's video, we want to really critically look at what we mean by defamation and be able, at the end of the day, to achieve these learning outcomes. Be able to define the thought, we'll be able to identify the elements that we could bring out from that definition, understand the classifications, and then distinguish these classifications, which are usually called libel and slander, and understand circumstances where slander is actually perceived. Why we are saying that will be evident in the course of the presentation. Now, the definition, which I mentioned in the last presentation, is simply, if I want to say it in simple terms, is to say just making false accusations, statements about a person which affects the person's reputation. If we were to put it in layman's terms. In the legal language, we talk about it as a publication of or concerning a person, which is calculated to lower that person in the estimation of right-thinking members of the society. You notice that I underline, some words are in bold, they are emphasized, or cause that person to be shunned, ridiculed, or avoided, or something, a statement that conveys an imputation on that person, which is disparaging or injurious to his office. And in articulate forms, of course, you know that we'll dissect this statement and find out what it's actually saying. So in that statement, it says it's a publication. The truth is, the matter is that the law expects us that it's been said that if you have nothing positive to say about someone, then keep quiet. Because once you say something negative, you actually run the risk of being liable in defamation. Okay, so if you have nothing good to say, why not keep quiet? But today, in this information age, everyone is saying one thing or the other to various means or the other. Now, so statements that make that is about the person of another, and that other is usually the plaintiff in the course of action. And that statement, lowers that person in the estimation of right-thinking members of the society. So the law is going to interrogate that and say, okay, how would right-thinking members of society, not just anyone, how would they view that person in the light of the statement that you have made, or which causes that person to be shunned or ridiculed, or avoided? And you have the case of Abalaka and Kisete, where the Supreme Court re-emphasized this definition that had been made in earlier cases like in Sketch and Ferry, NTA, and Balatope. So in that statement, in that definition of what is defamatory statement, you have publication mentioned. It requires that it be published. In a publication in subsequent video, what do you mean by publishing? It's not sufficient that I stay in my room and I make a statement to myself. So what do we mean by publication? We'll be looking at that. is made about a person. Who is the person? What kind of person can come before the law? It must have an effect on the person's reputation. The statement, defamation, the essence of the thought of defamation is that it protects your reputation. You know, every thought has an aspect that it protects. So in this context, we are looking at your reputation. And what do we mean by your reputation? We are looking at how you are viewed by third parties, not your opinion about yourself, but what other parties, third parties think about you. It might be that it causes you to be shunned or ridiculed or avoided. And so we'll be looking at this in subsequent discussions. For instance, if you see someone who was raped, I mean, it might cast some measure of pity, you know, on that person. And the question is that defamatory? Especially when it is not true, or even if it is true, what is the implication? Don't forget we said that defamatory statements usually false statements. So in that statement, in that definition, it says that it causes you to be, you know, it affects your reputation, the plaintiff's reputation in the estimation of right-thinking members of society. So the idea is that what the defendant has said is weighed in the balance to see how ordinary members of society, people that are thinking right, how would they construe that statement? If you make a statement amongst a group of thieves and say this person is the chief of thieves, it could actually it could make the day to be night with his violence. And they consider that as a good conduct in their group. Those groups or that group of robbers, of hooligans, for instance, will not be right-thinking members of society. Okay? So if some people subscribe to a standard of conduct which are not those of society generally, for among the thieves, for instance, they expect you to be violent, to be, excuse me, pardon me, to be violent, to be, you know, to be mean, to kill and to maim. You know, those are not right-thinking members of society. So the statement will be such that any right-thinking member of society will think like so few. And the emphasis of the course have been that it will be men of ordinary intelligence. What would they ascribe to that statement? How would they see that statement? If you see somebody is a prostitute, you know, because if you see somebody stole from the government treasury, would you say, oh, he has done a good job? Or would ordinary men, ordinary people in society, people of ordinary intelligence, how would they ask, or what kind of reasoning they ascribe to that kind of conduct? Okay? And in this context, words are taken in their ordinary and fair meaning. So in terms of constrained members of society, what the law is saying is that you cannot just put yourself in a box and say we subscribe to this particular standard, and that standard is what we are going to judge the statement by. Okay? If your standard is not that of reasonable members of society, if you are, for instance, overindulgent in criminal tendencies, in immoral behavior, you know, if you belong to a cult or to some association or relationships that do not view what reasonable members of society would consider as derogatory, you know, if you do not view them as derogatory, then that means you are overindulgent, you are subscribed to a standard that is not reasonable. And that is not what will be the basis of an assessment of whether a statement is defamatory or not. And then there are those who are particularly strict on the other side, who would think the less of a person just because of the most minute infraction of you know, or conduct. The law is not going to also subscribe to their own standard in terms of what is a defamatory statement. The classification of defamation, like I said earlier, is significant because of some legal reasons, and we'll be seeing this. Usually, defamation is classified into libel and slander in most jurisdictions. And when we talk about libel, we're talking about defamation in written form. It's in permanent form. A book, anything that is permanent form is regarded as libel. And in such cases, the implication is different from when it is slander in terms of being able to bring a cause of action. So when it is in written form, or in permanent form, whether it is a book, a journal, a newspaper publication, or something that is recorded that you can repeat over and over again, we regard it as being in permanent form. And it's regarded as libel. While slander is spoken words that are spoken, things that are not in permanent form, things that are transient. In fact, it's usually said that libel is at it's attracts the eyes, while slander attracts the ears. Use the ears to pick up slander. Use the eyes to pick up libel. That's one of the ways that it's been described. Now, so spoken words, that's slander, or things that are not in permanent form. And you have some cases there, you have like an accusation again, and then you have the defamation law. You know, in the earlier video, I talked about the fact that there are some statutory provisions that also affect the law of defamation, and you have the defamation law of legal state as an example. And in that law, initially, the question was when telecommunications came into existence, how would you consider the telecoms industry publications like radio, like television? And now today we have the internet, we have the so many forms of telecoms and ICT, and specs that you would wonder, okay, are they permanent or are they transient? But the defamation law then said that broadcasting by wireless telegraphy shall be treated as publication in permanent form. And actually, in most jurisdictions now, how you know that it is permanent form is that if it's something you can actually go back and repeat, it's permanent. So if it is online, you can actually go back there and pick it up. If it's on your phone, WhatsApp, if it's an email, these are things that are in permanent form. And the libel and slander, why does the law of defamation, why is it construed in two classifications, libel and slander? I said earlier that it has implications on the causes of action. In most jurisdictions, slander is only a tort, is only regarded as a tort. When spoken words, transient words, they are usually a tort alone. But libel is usually both a tort and a crime. When you make a speech, usually it's those who are there that will hear it. And before you know it, half of them may forget. This person is not as strong and effective as when it is in written form. Documents that are 3,300 years old could be dug out and be transmitted even today. So the weight that slander carries is not as heavy as the weight that libel carries. So that's one difference between the two. The second one is that libel is actionable per se. Once you have that written publication, it's usually actionable without proof of special damage. And the plaintiff does not, the law presumes that the plaintiff has suffered damage or injury to his reputation. It is presumed. You don't have to come to court and prove that damage. It is presumed that your reputation has been damaged because it is in permanent form. Okay? And the law court will usually award general damages as compensation. You have intended and aladi and party headed against Palmol Limits and party headed and Palmol Limited against Ofio Nigeria Limited and another. So it's usually that it is libel is actually per se without proof of damage. While slander is not actually per se, as a general rule, slander is not actually per se. The spoken words, the non-permanent publications, you must prove special and actual damage to your reputation. You must prove actual damage, some material or financial loss of money or some temporal or material advantage that is estimable in money. You must show that there was some loss that emanated from those words that are slanderous. That's, so that's general regarding slander. That slander is not actionable per se. It's not just sufficient to say because somebody has uttered a statement orally, then that you'll be liable in defamation. But there are some situations when slander will be regarded as actionable per se. the law will regard as actionable per se. When you impute a crime, okay, you put imputation of a crime against the plaintiff, a crime that is punishable by imprisonment or capital punishment, then that slander is actionable per se. Okay, so when you impute, suggest the fact, you make a statement of fact that person has committed a crime and that crime is punishable by imprisonment or capital punishment, then that's slander, even though it's a spoken word, it will be actionable per se. Imputation of infectious diseases are also actionable per se, because in the traditional and the historically, infectious diseases will lead to aspersion, ridicule, scorn, social isolation. These are things that you do not play with in the society that's from which modern world evolved. And these laws are still there. So any kind of infectious disease, if you input it, I mean, like saying someone has a venereal disease, the implication is that that's, of course, that is sexually, transmitted to that person. Taking it further, you may want to say the person is promiscuous. So if you impute that, then it's as a slander, it's actually per se. You input that a woman is unchaste and is immoral. You say she's promiscuous. She's sleeping around. She's having an affair, with maybe a married man or something. Anything that denotes that a woman is unchaste or immoral, even though it's a slander, would be actionable per se because of the consequences. These laws evolved in the society in which, for instance, the chastity of women was held in high esteem, and the woman was found to be unchaste would suffer a lot of negative reactions in the society, in the family, in marriage, and what have you. Then when there's an imputation that affects the business or professional reputation of a person, and at common law, what law was that if you impute misconduct in the way of business, to say, for instance, that a priest is immoral, that is having an affair with a member of the choir, to impute that a doctor, raped the patient, to impute that a lecturer is, having an affair with a student. So these things that affect professional calling, or, the common law position was that the misconduct that you're alleging the person to have committed must demonstrate that it must be shown that it was in the course of duty, or it must show that the person is unfit for that duty. But so it must really attack the essence of that professional calling. Okay, the essence of that professional calling. The statute came in, for instance, the permission law of Lagos State and other state laws, to say that, look, you do not need to preach when it comes to imputation affecting the business or professional reputation of a person. In this context, we are saying that that slander will be actually passed. Don't forget that we keep emphasizing the word slander. So it's not just any kind of defamation, but the one that is a slander, okay, ordinarily will not be actionable per se. But we are saying in these four instances, the slander will be actionable per se, okay? But the law now is that even when it's not a misconduct that is attacking the essence of that business or professional reputation, it is still actionable per se. So no need to put special damages in this context, whether or not the words are spoken of in the way of his office or with a profession. In conclusion, the elements of defamation that we can obtain from the definition require that there is a publication about the plaintiff, which is defamatory, which has caused him to be shunned or ridiculed, conveying an imputation that is disparaging to him in his business or his professional calling, in the eyes of right-thinking members of society. So if you are saying people are looking at you and this person has destroyed my reputation before members of society, these must be right-thinking members of society. How would right-thinking members of society construe this statements that defendants is alleged to have made. We've also been able to establish that there are two classes of defamation, libel and slander. The two differences between them, the general rule regarding slander not being actionable per se, and the circumstances in which slander will be actionable per se. The implication of all these, therefore, is that when you have your cases or your questions in an examination condition or in practice, and you need to determine first that the statement is defamatory, and to determine which category of or classification of defamation, whether it is libel or slander, so that you would know what is required to be proven before the court. If it is libelous, then you know that it is actionable per se, without need to prove special damage. That is, if it is a slander, then you know that the general rule is that slander is not actionable per se generally, but there are exceptions to this general rule where slander is actionable per se. In the next presentation, we shall continue with other aspects of the thoughts of defamation.